Good evening. Welcome to Reasonable Doubt. I'm your host, Todd DuPont. Hello, Happy New Year, 2014. Yes, we are actually live. At some point here in a minute, I suppose my still producer, Mark Purtle, is going to put up the phone number, and we're going to ask you guys to call in. But Reasonable Doubt, for those of you that have never watched before, is a weekly live call-in. I say weekly. We're trying to get back to that. Weekly live call-in talk show that's sponsored by the Harris County Criminal Lawyers Association that typically deals with matters in the criminal justice community. So I, on behalf of myself and HCCLA and my guest here this evening, appreciate you tuning in and watching tonight. And we are going to jump right in without any reserve because we have one heck of a good guest. So let me start with my co-host, Mr. J. Julio Vela, also known as JV.
2014, pleasure to be here. We have a spectacular guest also, so.
How are you today, JV?
I'm good. I'm great, never been better. I'm looking forward to the new year. It's a good time.
Well, we get to kind of start over. I mean, the year starts over by proxy, but we have another 12 months to figure out what we did wrong last year and try to make some improvements this year.
Fix what we can and do what we can every day.
Well, tonight, I'm very honored. I've been asking for a while and had finally got it to happen, to have as our guest, Mr. Tyrone Moncriffe, an outstanding lawyer. His resume is unparalleled, and it's going to be very tough to find a lawyer that meets this man's credibilities. I will let him introduce himself to some degree, but first of all, thank you for coming on tonight.
It is, Todd, it's an absolute, you and JV, it's an absolute pleasure to be here. I'm still living up to trying to finish my 2013 resolutions. So I haven't quite made the ones for 2014.
Isn't that how it works
yet.
sometimes?
I still haven't finished those yet.
You know, it's crazy. Sometimes it's better not to make them.
Don't make them, just go do it.
Well, that's actually a good point.
No, it's a pleasure to be with you guys. And, you know, you guys both have great reputations, and it's an honor to be here. You and I have been talking a long time about coming, so it's a pleasure to be here today.
Well, and just if we have a crossover, you and I did an interview on your radio program.
Sure did. And that's why I had to be here for yours, because you did mine without hesitation.
And I heard some pretty good things behind that interview, too. And, it's like time ran out on us. We actually didn't get to finish talking.
We didn't have enough time. That's what happened.
So we're going to extend that interview to some degree.
Let's do it. Let's do it.
This one's here live in front of the city of Houston. So I do want to get some background just for the viewers that may not know you. Can you give us a little bit about your background? Where'd you grow up? How'd you get here?
Houston, Texas, raised here in Houston, Texas. Went to Worthing High School. Worthing Coat, my Worthing Coat classmates out there. Then I went to Texas Southern University, undergrad school, decided to go to law school.
What made you do that?
Interesting story. In my second year of undergrad school, I didn't know what I wanted to do. One thing I wanted to do, I had a cousin who got in trouble right here in Harris County. We went down, the whole family, supporting my cousin. And I'm sitting in the back row, and I'm watching these lawyers up there, and I said, wow, I sure like to do what those guys do.
So that was the old building?
That was it, old building, Harris County. Went home, and I told my grandfather, I said, you know, I want to be a lawyer, but I don't think so. I think I'll do something else because I don't speak well enough to be a lawyer. Spoke horribly, and so I think I'm going to do something else. My grandfather pulled me aside and told me something I've never forgotten. He said, don't ever let your limitations in life determine what you do in life. And I didn't understand what he meant. And he said, what do you mean by that? He said, if you want to do something, go find out who's doing it, who's the best at it, and ask them a question. How did you do it? So he said, you have a problem with presenting yourself. Go find out the best presenter that you can find. Well, that same night I turned the television on, and Barbara Jordan, the great Congresswoman, that Barbara Jordan, was on television. I was about 20 years old, and I was the type of person who, once I said I was going to do something, I went at it.
Sure.
So I started calling Barbara Jordan's office.
Come on.
Every day for about 3 weeks in a row. Finally, the lady said, look, don't call us anymore, please. What we'll do, son, we'll give Miss Jordan your number. We'll have her to call you. Sure, right? I left her my number. A couple of weeks later, if you believe it or not, Todd, JV, I received a phone call at my mother's house. I picked up the telephone, and the golden voice of Barbara Jordan was on the phone.
Wow.
And I asked her, told her what my ambitions were. I told her what I wanted to do. I told her my dreams, and she said, you forgot to think bigger. And she gave me these lists of, if I wanted to be a lawyer, be one of the best. Don't just be the mediocre. And we talked for about 20 minutes. And as I finished talking to her, Todd, I said, look, Miss Jordan, I have a lot of friends. If I tell them that I talked to Barbara Jordan on the telephone, you call me, they're going to laugh at me. Nobody's going to believe it. So I said, could you do me a favor? Could you send me a letter attesting that we talked?
Which is back then the way that, because there
That's
was no
the way.
email.
There was no email
right.
before internet, folks. Way back in the Stone Age days.
A letter was sufficient, if not golden.
Absolutely. So could you send me a letter so I can have something to memorialize and say I talked to Barbara Jordan? She laughed. She just laughed, fell out laughing. She said, I'll do it. And next couple of days, I got that letter.
I'll be.
Now, I never tell that story, JV, because the last time I told that story, everybody said, we want to see that letter. So I have the letter here.
Nice.
Wow.
And I wanted Todd to see it because I know if I told him, he would not believe it.
I wouldn't believe it.
Nobody believes it, but
November 2nd, 1976. Barbara Jordan, Member of Congress. This will acknowledge and thank you for your kind and thoughtful letter. In answer to your question, I do not know what you can do to become an eloquent speaker and penetrating thinker. As far as I can remember, I've always spoken the same way. As for thinking, one must be able to develop a strict discipline for concentration. You must decide whether you are willing to do this and then set up your own rules to follow. Self-improvement is important, and it is a very personal decision. Thank you for contacting me. This is really, this is worth its weight in gold.
you better believe it. So I keep it in my office, and one day my granddaughter may be able to make millions off of it.
Wow.
That's how I decided to become a lawyer, because she inspired me to
great.
go beyond my limitations. We all live within certain limitations in life, but she inspired me to go beyond that.
So
That's why I became a lawyer, JV.
So what was it that, there's all kinds of lawyers, but what was it that made you want to be
Criminal lawyer, criminal
criminal
defense lawyer. I think it was because I was a storyteller as a kid. And I watched the criminal lawyers, criminal defense lawyers, they were the better communicators. They could get before an audience, they could tell stories, they could enrapture an audience, and they could spellbound people. So that's why I really decided. I had a hunger for standing before an audience, speaking for jurors. That's part of the reason.
Well, and I think nationally, it certainly, I'm not going to limit you to the nation. But I certainly am comfortable limiting you to the United States. You're known as a storyteller.
Exactly.
Not just Texas.
Right, I know. And that's part of my reputation. Let me tell you something else, too. All kids have talents. And your kids, I think you have what? How many kids?
3 daughters.
3. Each one. JV, you have?
one?
One. All of them has talent. And when I was young, I'm the oldest of 5 boys. All my brothers have talents, major talents. I only had one. I could take a piece of paper, Todd and JV, write words on it, and make you turn the page. Write words on it, and you'd want to turn the page. I could write a story. I could tell a story.
Where do you think that came from?
I don't know. I don't know where it comes
You
from.
ever thought about it? Because
Never.
she asked about deep concentration and thought process, and I certainly agree with her wisdom in her words there.
Right,
You have to, like most trial lawyers that I know that really care about their craft,
right.
they wake up in the middle of the night and make notes.
Exactly.
They can't go to bed because they're thinking about this stuff.
It never leaves you. It never leaves you. What can I do with this? This is somebody, JV may make a sales statement. I said, I could use that. in this trial that is coming up.
Right.
So we're always looking for, but I think it was a natural gift that I had to tell a story. And it was fine until I went to law school. Law school took all of the attributes of storytelling out of me.
It did.
Okay? Every one, okay? Let me turn this off. I forgot I had the telephone on.
I forgot to remind you of that, but
Okay.
it's okay. It's a sign
But-
of a good
but-
lawyer. Phone's ringing.
Client telling me I don't have the money to pay you.
Well, I understand that. I understand that.
But that's what it was. Todd, it came to be being able to use words before an audience. But it's different than writing a story and then standing before 75 people and telling a story. That's a different craft. And I think that's what young lawyers need to learn. We was talking, JV, about learning the craft of standing before an audience and telling the story within the story. And what I mean by that, I don't mean just your client ran the red light or your client stopped for the DWI. That's not the story. What's the story within that story? And I think since I try a lot of cases that are murder, capital murder, you know, Todd, I have to get sometimes the underlying stories in stories.
Sure.
Okay?
As much as the court will allow us.
As much as they allow it. As much as they allow it. And sometimes I found, Todd, that the judges get into the story themselves and they'll let you go.
I won't say this particular judge's name, but this particular judge gave me 25 minutes to argue. It may have been a murder case back then.
Uh-huh.
And 45 minutes into the case, that particular judge, without giving gender, was still enthralled in my story.
That's exactly right. I watch you.
Without any objection.
Objection. I watch you, and I know you're an excellent storyteller. And that's, JV, I was telling you earlier that I learned there are two types of lawyers. There are good ones and there are great ones. Good ones are good communicators, but the great ones connect to human beings at a different level. And that's what I wanted to do, Todd.
How do you feel about, because I want to start getting into some of your things that we want to talk about tonight. How do you think about storytelling versus media? Because PowerPoints are showing up in trials today. I'm guilty of using them myself. I have mixed feelings of them, but I also think that in certain regards, jurors are so in tune to having, 2 or 3 second news bites that, how does a good old fashioned storyteller meet the modern age, like in terms of still being an effective advocate for their client?
I don't think nothing is ever better than a story, a good story. I don't care how much PowerPoint you use. I don't care how many, what all the technology that you use. Nothing replaces a story that if it's told where the narrator disappears. And let me explain to you what I mean.
Please.
If I've seen prosecutors, for example, get up and they have their PowerPoints and they step away from it and just talk from what's on the PowerPoint. But the good storyteller can stand before an audience and create its own internal message. Let me give you an example.
Please.
Let's say if I'm representing a young man who's charged with aggravated sexual assault of a child. You and I know, guys, this is the worst type of charge you can have, outside of capital murder. The audience, the storyteller, feels the venom of the audience when you walk into that room. And
Once the judge reads
once the words come out. Once the words come out that this is an
there's a hush that comes over that juror.
There is a hush, and JV, I don't know if you've tried any yet, but there is a rhythm in that room that if you don't feel, it's there.
It's
And
palatable.
I saw a great storyteller representing a young man charged with aggravated sexual assault of a 6-year-old child. And rather than getting to the PowerPoint, the prosecutor had the brilliant PowerPoint. But he got up and just said this, ladies and gentlemen, being a lawyer, I don't get to pick up my daughter from school very often. But one day I had to. And when I went by to pick her up, they wouldn't let me get her. Oh, I gave her my identifications, my name, everything. They wouldn't let me take her. And it wasn't until my daughter came down the hallway and said, yeah, that's my dad, that they let me take her. I didn't get mad at those people. They were protecting my daughter.
Right.
And I didn't get mad at you, ladies and gentlemen. When the judge said this is an aggravated sexual assault of a child, all the women pulled back, the men frowned. I didn't get mad at you either. We're a society to protect our women and our children. And there's nothing worse than this type of case, except one thing.
Right.
An innocent person being charged with this type of case. And Todd, I sat there in the room and I watched the energy shift. I watched the room shift. He didn't use PowerPoint. He didn't mention his client at all, literally. He told a simple story, but what happened with the story, the audience no longer, the narrative changed in the courtroom. It was no longer about the client with the aggravated sexual assault of a child, but it was about a man whose daughter walked in and said, that's my dad. The subtleties of that audience connected to him as a father, not as a lawyer. See what I mean? So the PowerPoint was like diffused because he was able to take him to that story, take him to that little girl walking down the hallway, and the jury went there with him.
Right.
That's what storytellers do.
Well, and I must ask this question because we didn't get to talk about this on your program, but you've been around long enough as a trial lawyer where back in the day the defense lawyer wore the white hat.
Absolutely. Right.
Now I'm not necessarily agreeing that the prosecutor wears the white hat and the defense lawyer is the enemy.
Right.
I don't know the power struggle, the shift.
Right.
I would say that it's not like it was in the 60s and 70s.
Oh, I'll agree.
Where most folks just candidly did not trust the government.
Absolutely.
But there may be some shift on both sides of the aisle that distrust the government.
Right.
And it may not necessarily be for criminal justice reasons alone.
Right.
It could be for spending or for other reasons. But as you became a lawyer through that process, how did you reconcile that shift, if at all?
Oh, I saw the shift too. I'll agree 100%. I have to address it. One thing I've learned, and you and I have talked about this before, Todd, I never ignore the elephant in the room. When I walk into a courtroom now, I know that my client is accused of a crime and is assumed to be guilty of that crime. And I'll address that. Ladies and gentlemen, I know the assumption is that he's guilty.
Right.
How many of you feel that way? Just be honest with me. Let me tell you something I've learned too, Todd, JV.
What will they say?
That some of them will raise their hand and say, yeah, you're right. And I love those jurors because they give you an option to take it from there and have a conversation. But I've learned that it is hard for us to acknowledge what's right in front of us. This jury has walked in. My client is sitting here at the table. There's a judge. There's a prosecutor. He must have done something, or he wouldn't be here.
I ask that question every.
He must have done something, or he
would not be here.
Exactly. And then what I do, being a storyteller, Todd, I try to always use something that the jury can acknowledge and see. And what I mean by that, I don't talk about indictment. Some lawyers talk about indictment. I talk about indictment differently. And let me explain to you what I do. I'll ask juries, how many of you have ever had a traffic ticket? And then everybody raised their hand. And I explain to them that a traffic ticket is no more than a piece of paper that they give you notice of what court to go to, what you ran the red light, ran the stop sign or whatever, what court you go to, etc. So I let them know that. And then I asked them, how many of you were guilty of the traffic ticket? Some of them raised their hands. And how many of you were not guilty? And those who were not guilty, I asked the question, what did the police said that you did, you know you didn't do? Mm-hmm. And I get them in a conversation about. And then from there, I make the traffic ticket analogous to an indictment.
Right.
That some people challenge the traffic tickets and some people challenge indictments. Mr. Jones is challenging this indictment. Ms. Smith, how do you feel about that? Oh, I think he should. You see what I mean? So what we've
Which
done,
is a form of empowering early on.
absolutely, absolutely, it's allowing them to participate with the fact that this man is doing the same thing I did with my ticket. This is now it's no longer an indictment that I saw on television, but a traffic ticket.
Right.
And so what I do in trial is try to take complex subjects and make them real simple so the jury can digest it.
And you know what? I've done this 15 years. You've done this much longer than me. But I believe, gentlemen, that we can take the most complicated legal issues known in criminal law and still make them analogous to somebody's life.
Everybody's life. Exactly. Everybody's life. It's something that's happened in your life that if you can make it analogous to this jury, you can get them to see it.
Well, like presumption of innocence.
Right.
Like there's an example where the kid breaks the cookie jar, right?
Oh,
or
boy.
the
Oh,
mother
boy.
walks in and finds the cookie jar broken. And then the kid with crumbs on their mouth. And is there a presumption of innocence here?
Right. Exactly. Or the one where your client, and JV, you'll find, being a young lawyer, you're going to find where you're going to have some cases where your client will have a criminal history, and you're going to have to put him on the stand. Todd, you know what I mean?
Yes.
And you're going to say, wow, my guy has 3 prior burglaries, and now he's charged with a burglary. And you can use analogies with that. I've had the cookie jar story also, where I've stolen the cookies and it was always me, except one time.
Right.
But since I had always done it in the past,
Does that mean I'll do it this time?
Assume that I did it this time. So you make analogies. People can see that.
Well, and I want to highlight. I mean, you gave, I think, the best example of the story that I use, and JV has said he's now using. The first question I prefer to ask a potential venire panel, jury panel, is what's the one thing worse than a person accused of whatever crime there? And I've actually learned that it works for small cases. It's probably better for bigger cases.
Right.
And some of them will say, let's just say the allegation is aggravated sexual assault of a child.
Right.
Some people may raise their hand and say, well, murder's worse than that.
Right.
Some may say, well, capital is murder's worse than that. And I'll kind of let them answer without commenting. And then somebody, invariably it's the third or the fourth person for me, will say, convicting an innocent person of that offense. And like we talked about off air, that sets the tone on their job there.
Absolutely.
And if they can articulate that up front, then perhaps, they consider the jury panel kind of a herd, right? They've
Absolutely.
been herded from here to there. They've had to wait. They're building relationships, and that's not necessarily meaningful relationships, but at least topical and
you're outside of the herd.
Right.
It's a herd if you're outside, and I've learned too. Good point. That you cannot attack the members of the herd if you're outsider.
Right.
Because the whole herd turns on you. So you always have to be very polite, delicate with people.
And let the herd give the answer.
There you go. Exactly.
I guess the hat trick becomes positing a question to introduce to the herd, to let the herd, I'm using this but as our dialect here, but the herd vets the answer and gives it back to us.
Right, exactly. And their answers is much better than yours.
Right.
That's why we were talking about PowerPoint. The answer on the PowerPoint is not the answer. The herd gives the answer. Once they give an answer, they embrace that answer. Don't try to give the answer for them. Right. I teach young lawyers in Huntsville on the methods of cross-examination, for example. And I always say, you let the listener reach the conclusion. You don't tell them. If you're telling them the conclusion, they don't, it's different.
Right.
And what I mean by that, Todd and JV, is let's say I can say a man is drunk. That's my conclusion. You may disagree with that conclusion. But if I tell you, John was standing at the corner, his eyes were bloodshot. He was weaving backwards and forward. When I walked up on him, his breath smelled of alcohol. He fell, had to lift him up. We walked him to his car, and he stumbled, mumbled, couldn't understand a word he was saying. I don't have to say he was drunk. You do.
Right.
And when you say it, then it's your story, not mine.
They've taken it as theirs.
Your story, exactly. And I think you should do that whether it's an opening statement or cross-examination, direct examination. Okay?
All right. I want to take a moment to, where are we at? A half hour in already?
All right, that fast?
I know, that crazy. But yes, listening to this man is.
Oh, we'll talk forever.
It's, but I'd like, if you're watching and you'd like to call in, this would be a good time. I know I got a couple more pointed questions for Tyrone, but 713-807, what is that? Mark, I can't even read the new 1794? All right, well, the number's there. There you go, Mark. Call in, because this is one of the best lawyers in the United States, and I'd hate for you not to have the opportunity to ask him a question. All right, I think we can all agree that voir dire, most people would say that voir dire is one of the most important, if not the most important parts of a criminal jury trial.
I think so. I think so.
But I also think that the 1-2 punch, a good opening behind voir dire to me is when some would say, and myself, depending on some parameters, would mean that the case could be won or lost after opening. What are your thoughts about that?
I'll agree 100%. I think what happens, you give a slant to the case. It doesn't necessarily mean you win or lose, but you give a slant. And what I mean by that is this. Let me give an opening statement. One of the ones I usually do when I do presentations, and I'm going to kind of do it quick.
Sure.
If you had been at Main and Travis on August 13th, 2012, you see Mary Smith. She's walking toward an apartment, Marbury Apartments. Room 116, the door is slightly open. Mary's going to see her sister. Her sister's 2 hours late, but she's never late. She opens the door, and the front room is spotlessly clean as usual. She walks to the kitchen area, and on the kitchen wall there is a red arc of blood. And on the floor is her sister, and her head is sliced open like a watermelon. She screams, and she screams, and she screams. And she didn't stop screaming until she heard the noise in the hallway. And she ran and remembered her niece and nephew. She opened the door real fast, and her niece was bending her knees and had her hand over her brother's mouth. And she said, "That man is going to get us. That man is going to get us. That man is going to get us." 2 weeks later, they took that little girl into a room. And 5 men stood in line. They walked to the center of the room, and then they'd walk back. Walk to the center of the room, and they'd walk back. And a man in a third spot walked to the center of the room and walked back and said a few words. The little girl said, "That man is going to get us. That man is going to get us." And ladies and gentlemen, that man is in this room. And he's sitting right over here. And I sit down. Opening statement. If I were a prosecutor, of course, I wouldn't want to do that if I was a defense lawyer.
Right.
If I was a prosecutor. But what I have done with the opening statement is set a scene. And what I have done is, by setting the scene, I've taken the jurors out of the jury box where they become witnesses to the crime.
Walking with you.
Right. Mm-hmm. They were witnesses to the crime. So they're no longer jurors. They're witnesses. And what has happened also too, Todd,
Sight,
JV,
color, smell.
I took all the senses of the world that I could use, JV, and I told everyone. And then by doing that, the storyteller places the listener there. They're no longer observing it from a distance, but they're actually participating. And once they participate, yes, it is stacked where they're going to want to find this young man guilty no matter what. Even if, and I talk about this oftentimes with young lawyers, even if the little girl walks in court and says, "You guys got the wrong guy. That's not him," that jury's still going to want to
They
convict.
bought into the story.
Because you know why? Because it wasn't the little girl's story who they saw. They saw the incident themselves. They felt the fear of the man in the room themselves. Doesn't matter what the witnesses say. It's what they felt.
Well,
That's how
in any
it's slanted.
no, but the reality is, in any capacity as an effective advocate, regardless of who you're advocating for, you have to know your facts. And not only that,
Right.
if you're going to be a storyteller, you can't just get up and say it was 9 o'clock, it was on Main Street, the car crashed into the other car.
Right.
And ladies and gentlemen, like my cousin Vinny, I'm going to ask you to find him guilty. I mean,
It doesn't work like that in
you
the
can't-
real world. It doesn't work like that in the real world. You've got to take them there. You've got to use all the senses. And more importantly, you got to act as though it's happening right now when you do your opening. This is happening right now.
you
Once
didn't
do-
realize you're getting CLE education.
I'm soaking it all up, man. I'm soaking it.
Well, ask this man a question.
So how
Yeah.
do you translate that into your cross? And so the state will present its case right after openings. And so how are you taking the relation to the jurors and the relating to the human being aspect, and then compounding that with creating the scene and involving senses, the 6 senses, right? 5 senses plus, that 6 we talk about. And how are you doing that through your examinations?
Well, I think you use the same tools. But as you know, every witness, every person who walks into the courtroom has a role in the story. You want to know what their role is. What could they see or what they couldn't see? If they're in an area where it was dark when they saw the shooting, how dark was it? You can make it as dark as you want to by the words that you use. Were they focusing on something else? Before the shooting, before the incident, what were they doing then? So you can use all your senses to sort of block it or enhance it, depending on what you want.
Said another way, I think I'd never speak for Tyrone, but yes,
No, you
leading questions allow us to frame their version.
Right.
Because and this isn't something new to Texas, this is new to a long time ago when the defense had the ability to ask leading questions well before the rules of evidence were promulgated.
Right, exactly.
We get to ask questions that get to lead the people or the witness, if you will, not necessarily the people, but at the end of the day, they're obliged to answer the question I asked, subject to the judge asking them to obey the question that I've asked, and nothing further.
Right.
And so, yes, if you have 4 witnesses that only have a piece of the puzzle, they're not going to be talking about everything. They're only going to talk about their piece as I deem necessary.
Right.
And of course, we've all seen cases where I asked no question of this witness.
Right. If that witness does not fit in your story, you don't want to ask questions to it, But also, you talked about something very important when you said voir dire. Set your cross-examination up in voir dire.
Interesting. And how elaborate on that?
Well, let me explain to you what I mean. Jurors come to court because they want to see the lawyer attack on cross-examination. They see it on TV. It's from Perry Mason to, Boston Legal. They see it. It's there. That's what's all on TV. Set it up so that jurors will know what cross-examination is when it occurs. And what I do is ask them, how many of you watch legal shows? Oh, they love it when I ask that because they start talking about the legal shows. And I tell them, how many of you watch the old shows and the Perry Mason shows?
Right.
Oh, yeah, we love them. None of that happens in real life, what Perry Mason does. And they get a good laugh about it. But then you show them how cross-examination is in a real setting. Example, car A hits car B, ladies and gentlemen. This is cross-examination in real trial. The witness says, I saw car A hit car B. Police get there. I saw car A hit car B. Talks to the prosecutor. I saw car A hit car B. Gets to the police station, he gets to the courtroom, the prosecutor said, what did you see? Car A hit car B. It wouldn't be very intelligent for me to ask the question, what did you
car
see?
did you see? Right.
Because I know his rhythm. I know what he's been conditioned to say. So my questions would be, there was a lady across the street, wasn't it? Yes. She had on a red dress? Yes. Attractive lady? Yes. Had a purse in her hand? Yes. Very attractive lady? Yes. What took your attention away from her? Well, I heard a crash. What took your attention away from her? For dramatic effect. I heard a crash. No further questions. Then I know the juror is going to say, I say, well, why is it I'd say no further questions? Somebody's going to say, well, because he never saw it. You know, I know it, okay? Why is it that he never saw it? Because he only heard it. Then I said, do you think that witness will ever say, I never saw it? No, he's going to always say I saw car A hit car B. You're conditioning them to wait for you to ask a question. You see what I mean? Not only do they see the pattern of cross-examination, but they're going to say, look, in trial now, they're going to say, JV, boy, don't worry about direct. JV is going to tell us the real answer. We're going to wait till he does cross-examination.
Well, and the other thing, if you really just dissect what he just did here on air, is he never asked a question he didn't know the answer to.
Right, exactly.
You didn't ask the last question. Had you asked, what did you see?
Right.
Could have been the fatal last question
Exactly.
to ruin a good cross.
Exactly.
Which
exactly.
is, I turned, yeah, I saw that person.
Oh, yeah, I turned afterwards.
As soon as I saw that, they stopped short and I wrecked into them.
Exactly.
Do you
know
see how one question could be fatal to the cross?
Knowing how to limit your cross, get what you want and get out of it. Get what you want, make your point, and leave it alone. And then
Well,
go
because that becomes the jury's purview.
Exactly, exactly. And they've watched it. They watch you doing, you know, we were talking about
That's
voir
a
dire.
great example. That is fantastic.
I use that in trial. Use it too. So any of you young
really,
lawyers,
really,
use
really
it.
good example.
But you talked about something very important. You talked about voir dire. Let me tell you something. I've learned this. The great lawyers I've watched, and I've watched some of the best. I mean, from Racehorse Haynes to you name it, Jerry Spence, Craig Washington, all of them. I learned something. They were doing something that I did when I was a kid. When I was about 8 years old, my father made me and my brothers go out and sell newspapers. I didn't want to do it. We had to go sell newspapers on Saturday mornings. Didn't want to before we can go play. After about 2 weeks of selling newspapers, I noticed that all the people were coming to me to buy papers, not the other kids. Didn't understand why. A lady told me why. She said, Tyrone, do you know why we're coming to you to buy papers? I said, no, ma'am. Why? She said, because of the way you address us when we come up. I said, what do you mean? Then I noticed the other kids, when someone would walk up, JV, they'd run up and say, you want to buy a newspaper? Well, not me. I said, Mr. JV, how you doing today, sir? Would you like to buy a newspaper? That was the only difference, Todd. But let me tell you what I learned that I was doing. I was acknowledging them first. Then I'd ask to sell after I acknowledged them. And I was a kid. I learned during jury selection, acknowledge your jurors. Do not let them be a number, JV. When you got your list of jury list, don't say that's jury number 7, jury number 8, jury number 9, and lady says something about, well, you know, my mother died 3 months ago, so I know, well, jury number 9, what about this question that I have for you? Acknowledge the fact that a human being has gone through pain. And stop your voir dire and say, ma'am, I'm sorry to hear that. And once you acknowledge her and treat her like a human being, then the herd that we talked about will now make you a part of their group. Okay? So that's so important. You talked about, because you're the salesperson, not your client. You will always be the salesperson. You're the narrator to the story. You conduct the story. You tell the highs and lows of it. And another thing, don't ever lose, because I've had this to happen to me, and Todd, I don't know about you, you cannot lose your credibility with a jury. If they see you said something that just wasn't there, you're gone.
It's over.
It's over. You know, part taught it's over. Always maintain your credibility.
Well, let me
Always.
get to agreed. I mean, that's almost.
You got about 15
Some would think that that's 101, but like my dad was not a lawyer in the age where you win at all costs.
Right.
At some point back in the day, lawyers tried cases and would shake hands, have a cup of coffee or a beverage, adult beverage after that, and see each other in the court the following day.
Right.
Somewhere along the way, and I've seen it pull back, but maybe in the 90s, and there was some point where everybody wanted to win at all costs, and that's not the spirit of the way you're supposed to practice law. It's certainly not the mandates of what the code or the ethical requirements call for the district attorney's office.
Right.
But be that as it may, yes, at some point we have to have camaraderie in this deal simply because we're all every person down there, from the bailiff to the coordinator, name everyone in the courtroom, is there for the accused.
Right. Exactly.
We're there to serve the accused. It doesn't feel like that no often.
It sure. Look, I've been doing. You said 15. I've been doing 30. This is my 30 year. I've met a lot of people. I've tried a lot of cases, and every time when it's over with, I'm not saying I always get along with prosecutors, but I try to treat them with dignity, and I'm polite with them afterwards and before. I congratulate them whether I win or lose.
Right.
And my dad always taught me to be classy about what you did. And let me tell you, that has come back to help me, because some of those prosecutors I've gone against, JV, became judges later.
That's true.
And the rapport that you develop as human beings is always important. I think you're right. Being a gentleman or a gentle lady about what you do, having your own sense of dignity, transfers to a jury also.
I want to get your thoughts about summation, closing argument.
Sure.
If we follow closely what we said here, that some would promulgate, myself included, that after voir dire and perhaps even opening, the case may be largely won or lost, depending on the way that it's set up. What does summation or closing argument do to the case? Like, because I've had some folks tell me their mind was already made up.
Yeah, and
some are swayed by that.
Some are swayed, and it depends on how powerful everything was before. If you wait, though, to final argument to think you're going to win your case, you're in trouble.
Okay.
I think it's just about you. I don't think you necessarily can win it, but you can lose it in final. I think what you do in finals, you try. I go back to images again, and I go back to.
I've seen you give some powerful closings.
A lot of times.
I mean, you can't fall short. You have to go in there and punch out.
You've got to go in with what you have, and don't be afraid to say what's in front of you. For example, if you're in a situation where your client is about to, let me give you, and I'm not going to give an argument, but my client is about to face a punishment argument to a jury just found him guilty of murder.
Okay.
And you walk in, what does it feel like in a room? It's scary. I'm scary. I'm afraid. And I tell jurors, you know what, folks? I was afraid before I started, but there's nothing compares to the way I feel right now. This is real fear. This is real fear. And I can be real with them. It's talking about credibility. I'm standing up before you. I have 15 minutes to talk to you. This young man, you've seen him, you walk out and in and sit in those chairs. You don't know this young man like I do. You'll never be able to know him like I do. You see him sitting at the table. You see him put his head down and up. And that's all you see. Mm-hmm. But I've seen him start his old raggedy car up and it start knocking. I've seen his kid call his kids late at night. I've seen him work 20 hours a day to try to provide for family. I've seen all that. You haven't. And I can get real with them. I'm afraid. I'm afraid that I may not have been the best lawyer for him. I'm afraid there might have been a lawyer who's better. I'm afraid for his life because when I walk away, I want to be able to say to my children that I've done my best for that young man. I'll never forget him. You will, probably, but I won't. So I can take that story and I can make it real because this is what's happening right now. Don't be afraid to say you're afraid.
Right.
I'm afraid of you folks. You're very powerful. You go back and you make a decision on a man that you've only seen 4 days. And I've seen him 2 years, every other day, every other week. And now I must turn him over to you. And some of you will want to go back. The prosecutor, I always get them ready for what the prosecutor's going to do. The prosecutor's excellent lawyers, and they will scorch him, I guarantee you, when you get up here. And hopefully I have something to show that he's been a decent human being. But I get to the real gut feeling here. Todd, I don't know what our time is like, but let me tell you something.
Take your time. Mark will kick us off.
Good friend of mine, Mark Bennett. You guys know Mark Bennett.
Who missed our board meeting today because he was talking at the board meeting for the Montgomery County Defense Bar. So he was doing good. He just forgot to give me his proxy for watching, Mark.
Let me tell you what, Mark
Go ahead.
Bennett,
Sorry, Tyrone.
good friend of mine. Mark had been for years trying to get me to go to Jerry Spence Trial Lawyers College in Wyoming. I don't know if you've heard of it.
I have.
Go, if you can, young man. And I kept putting him off. Oh, man, okay, Mark, sure, I'm doing it. And I said, look, let me just send this application in and get him off my back. Sit down, fill the application out, and a couple of months later, I've got accepted. I'm, oh, man, I can't take off a month from my practice.
Right.
There's no way I could do it, but I kept putting it off, and I finally wind up going.
What year?
2000. Stan Snyder and I went up there together.
Okay.
It was the best thing that happened to me in terms of me standing before people and becoming naked and not be afraid. Because that's what we do. We stand before people. We take off the mask that was it T.S. Eliot said that we all put on a mask. You take the mask off and you let people see your inner feelings. And I found out going there, I thought that it was important for lawyers to always be strong. Thought that. But I found when I went to the college that sometimes at your weakest moment, you're your strongest. Your weakest moment, you're your strongest. So I when I'm talking to people, 12 people who
It's
sit
an interesting concept to debate, like to internalize. Like,
well, let me explain to you what I mean. I've learned to fix myself. And what I mean by that, there's something about all of us that needs fixing. We may not want to acknowledge, well, this didn't go right in my life, this didn't go right. But I learned to fix myself and admit to my limitations.
right.
And when I was able to admit to my limitations, I could stand before people and not have to be great at everything. I tell young lawyers, when you're standing before people, if you're nervous, say, I'm nervous. I'm not, if you forget your lines in your presentation, look, folks, I forgot that point. If you have to give up and do your presentation with notes, I have to do this presentation with notes.
It's happened.
Because I don't want to forget it. It's so important for me. I hope you don't mind that. Once you admit your limitations, human beings embrace you. And sometimes, believe it or not, with our cases, we need to be embraced with the jury. But that's part of it. Part of the final argument is knowing, Todd, yourself and not being afraid to stand before people and say, folks, this is going to be a tough case. I know it is. It's tough for me. We didn't select you, but we went through your names and said, I want this person on the jury because I can trust him or her with this human being's life. And you get them involved.
Well, as my grandmother said, if it was easy, everybody would be doing it.
Everybody would do it. Everybody would do it. But that's part of the thing. And also I use pictures. I read somewhere that Antoine Chekhov, the great Russian poet,
Yes.
was a photographer with words.
That I didn't know.
So,
No, in terms of that
oh
saying.
yeah,
He
photographer.
wrote what was one of his, Chekhov wrote,
He wrote You don't.
Sorry for the dead time. It wasn't the bet, was it?
That was Dostoevsky. I think Dostoevsky, if I'm not
Short
mistaken.
story, the bet.
Yeah, he wrote so many, but he was a master crafter of words, and he would take pictures with words. He was such a great person using words, and that's what you do in final argument.
I think that's what you personally. I think that's what you do. Like for my personal,
Right.
watching you, you're able to do. You've done this on the show at least 3 times tonight.
Take a picture. Take a picture with the words. How much time we have, Todd?
6 minutes.
6 minutes. Let me tell you guys something before we get off here. And you may have, Todd, you may have heard.
JV, I want you to ask some questions.
I'm soaking it all in, man. I'm soaking it all in.
Let me tell you guys a story, something that had changed me too when I was about to second year undergrad school, and those who've heard me do presentation always hear this, but I'm gonna tell you guys too. My teacher walked in, English literature teacher, and she said, "Boys and girls, we're going to do something different today. I want you to go to your refrigerators. You see your refrigerator? You see yours? Go to it. I want you to open a door, and you open a door and notice the light comes on, the cool breeze hits you about right here. There's a lemon in that refrigerator. It's the biggest lemon you've ever seen. And I want you to take one hand and pull it out. Notice the rough texture of the lemon, and your hand sort of drops. Put that lemon on the nearest table. But you roll it backwards and forward, backwards and forward, backwards and forward. Reach in the drawer where the knives are, and notice the utensils, the noise. Get the sharpest knife out, put it in the middle. Start to slice it slowly, slowly, backwards and forward. Notice the juices come out and you turn your head because of the smell. Mm-hmm. Slice it in 2. One side has seeds. Take that side of the lemon, squeeze it a little bit till the juices now come on your hand. Put that side of the lemon in your mouth and bite it. And boy, you talk about sour here. And I start feeling up here. And you know what I said to myself? I was 19. Wow, that's dangerous, what she did. I realized what it was dangerous because she was just using words, but she made me have a physical reaction. Mm-hmm. I saw the power of words. And that I realized that if you could use words to make a person taste a lemon, you can make them taste a banana, smell bleach. You can make them hear the accident down the street using words. Saw the power of words. And I began to see how if you utilize words in your presentation, you can create any sound, any feeling that you wanted.
Well, but I mean, it goes back to the trial counsel having to understand their defense. Mm-hmm. I mean, albeit not all folks are going to be natural-born gifted storytellers.
Right, absolutely.
I'm Cajun, so it was born into me. And we tell a joke that lasts 10 minutes.
It lasts.
Right. I mean, most of my jokes take 10 minutes.
Right. You got to build it up.
Right. But some people perhaps, what would be your advice to young lawyers that are shy or that
Take an acting course.
Seriously?
I do mean that absolutely seriously. Robert Jones, one of the legendary trial lawyers here, told me when I was quite young, take an acting course. It was one of the best things I did because it forced me to get in an audience and before people and develop a rhythm. And what I mean a rhythm, I mean there's a chemistry that develops when you and I are talking. Todd, when you and I are talking, giving interchange, a chemistry develops. You do that with an audience also. You develop, when you present with them, you're developing a chemistry. Acting allowed me to do that, allowed me to take that. I never could become an actor, of course, but it allowed me to get before an audience and not be afraid to develop the chemistry.
Okay.
Not be afraid of myself.
Yeah, all right, but would you also encourage some of the younger lawyers to find an older lawyer mentor?
Always.
Right.
Always. I watched, even when the lawyers, I just watched them. I go in court when I could, watch what they were doing. I'd ask when I get up time, why did you do this? Why did you do that?
JV's been going to court since he got his law license. That's kind of how we met.
That's
really?
right.
Yeah,
That's right.
absolutely. Keep doing it. Keep doing it. Because you're going to learn some things that work for them may not work with you, but you need to find out what works with you, with your personality, who you are, who's the core of JV, okay?
Right. All right, we've got about 2 minutes. Anything else you think you want to ask?
When was it that you finally felt comfortable in your skin in your practice? Like, I mean, did you have that kind of
You
defining?
mean in front of a courtroom?
Sure, in front of a, yeah.
Never.
Fair, okay, fair.
And I mean that. I heard F. Lee Bailey, one of the great trial lawyers, made this statement. If you ever start feeling comfortable, if you ever get to the point where you're not nervous anymore, get out of it. You never get in it. Every time you stand before an audience, every time you have a client's life in your hand, you should always be nervous. Because it's not nerves. What's happening is your body is getting you ready to perform. You know, it's an adrenaline rush. We think it's nerve, but it's the adrenaline rush. You're going to always have that. You never get rid of it, so don't try.
Well, I've got about a minute. I can't believe how quick this stuff.
We went fast, didn't we?
I'm gonna put it on. I hope we can live stream this. 'Cause I'm gonna and put it on because I'm gonna have this on repeat.
Well,
I mean,
HCCLA will have this. We didn't get any calls tonight. First show
That's
of
all
the
right.
year.
That's
we
right.
Didn't need them.
We don't need them. We can get to talking. We could talk another couple hours or so.
Well,
but
let me first thank my co-host, Mr. Jehu Luvella.
it's always a pleasure.
JV, thank you for serving on the board. We've got a long year. Well, I'm done in May in terms of my presidency, but I do trust to hope coming to serve the community by this program. Number two, and I'm just indebted to you. Thank you so much, Tyrone, for coming on.
Oh, you know, we always support each other. Anytime you need me, just let me know. It's been an absolute pleasure being here, meeting
Yes,
both
sir.
of you guys. Thank you very much.
Well, as just to wrap it up, I've got less than a minute. First of all, folks, Happy New Year, 2014. I really hope it's going to be a safe and prosperous year for all in the city of Houston. But here's what I want you guys to do when you get your juror summons. Go down there, obey your summons. Don't get out of it unless you have a good reason to. Go down and vote with your conscience. Come down. Good lawyers like these folks on this TV show need good citizens like you to come down, listen to the evidence, be fair and impartial, and judge according to the evidence. And really abide by the standard that's imposed upon the state to not convict until you are satisfied with proof beyond reasonable doubt, which is the title of this show. So we look forward to seeing you next week. I'm going to be trying to give my best to give y'all some good guests this year. So until then, we'll see you about this time next week. Good evening.